right, we have been watching live the cross-examination of former police officer Roy Oliver. Of course, this is his murder trial. He is facing murder charges for shooting a 13-year-old boy, Jordan Edwards, in the back of the head back in April 2017. I'm joined in studio by Evan Lipton, criminal defense attorney. Evan, we were just listening in to those first few minutes of the cross-examination. So first, let me ask you, how do you think prosecutors are doing so far in kind of trying to pick apart his story?
Well, I mean, we've only been at this for a few minutes to begin with. He seems to be holding up well. His demeanor is good. He's listening to the questions he's being asked. You heard him reject the use of the prosecutor's word zeal and replace it with his own word. But I think the prosecutor did a very good strategic move in beginning his questioning about this prior incident. This prior incident is very convincing. It really shows that this guy has a inclination to pull out his weapon in completely inappropriate circumstances.
Right. I mean, he calls it a collision. Prosecutors say it was a fender bender. He gets out, he pulls the gun. We also have Ashley Willcott with us live via Skype. So, Ashley, I'd love to get you to chime in. What do you think? Right move by prosecutors to bring up this earlier incident right off the bat as they did?
Absolutely. I think it was the right thing to do. It's very compelling testimony. The thing that I continue to hear him say, though, in his testimony on the current charges is that it's a threat, a perceived threat, and that's the reason he fired his weapon. So it's going to be really interesting to see how they can rattle him to see if he continues to insist that he had a perceived threat at the time.
Yeah, what do we make of this line of questioning, Evan, when the prosecutor says, well, you know the rules, you know that if you shoot into a moving car, you're very likely to injure or kill an innocent bystander, and he acknowledges that. Yes, he knows that from his training.
I mean, he's trying to show that this is a police action of last resort. You do not pull your gun and point it at a civilian unless you are ready to shoot them, to kill them. And that's what he did here.
Yeah, you know, right before we came back from our break, just looking at some notes from the courtroom coming out from reporters from the courtroom, I know that when Oliver was first on the stand with prosecutors, he made a statement to the effect of, well, if the driver had just stopped, this never would have happened. How effective is that, Ashley, to sort of put the blame on the driver for this?
I think it's really ineffective. What an asinine thing to say when you're a law enforcement police officer. You have a higher responsibility and duty. You don't get to blame it on the victim and say, well, they should have stopped their car. Right. Doesn't mean you get to open fire.
I want to get your thoughts on that, Evan, but first we need to take a quick break. We'll be right back with much more discussion and live testimony out of Texas in the Roy Oliver murder trial. Stay with us. We will be right back in just a few minutes. Welcome back to the Law&Crime Child Network. I'm Stacey Delikat, and thanks so much for being with us this afternoon. We are continuing to bring you live coverage out of a Texas courtroom where the former police officer Roy Oliver is now on the stand testifying in his own defense in his murder trial. It looks like a bit of a sidebar still going on, or are we going to go back in there? Not yet. Okay. Right now, I'm told that the attorneys in the courtroom are arguing over evidence, perhaps over whether or not to show some photos. We know that we saw the prosecutor tell Jordan Edwards, the victim's family, to leave a few minutes before this. I am joined by two guests today. In studio with me is Evan Lipton, criminal defense attorney. With us via Skype is Ashley Willcott, juvenile judge and trial attorney. Right before we went to break, Evan, we were talking about how Oliver said, well, if the driver had just stopped the car, this never would have happened, and also made a statement to the effect of, well, if these witnesses who were around in the 9 seconds between picking up his gun and firing it had said that car's not involved, this wouldn't have happened.
Right, so I'd echo what Ashley says. It's on the cop. I mean, this is his responsibility to be able to have the self-control and the awareness of what's going on around him to make these decisions. He cannot depend on a bunch of teenagers leaving a party to tell him where the gunshots are coming from. That said, I'd add one thing. Were he convicted, I do think that these facts might be relevant to sentencing. Might go to his mindset when he did this. It's not an excuse for the actions, but it might be relevant to the punishment.
Okay, interesting point. Ashley, do you agree with that?
Yeah, I do agree. I think that the sentencing is a good time that could possibly come into play and be a factor. You know, I'm thinking about reasonable doubt. And so is there going to be one juror that says, well, you know, it is true the car didn't stop and kept going and he had to do something. He perceived it was a threat. I don't think so. But you know what? We never know what these juries are going to do, quite frankly.
I want to ask both of you, are you surprised that Oliver decided to testify? We didn't really know until today when the defense began their case and called him. Evan, you're shaking your head.
I'm not at all surprised. I mean, his defense is that he had to defend his partner from being struck by a car. His partner has testified that he did not believe that he himself was in danger. There's no other way to get this position in front of the jury than by testifying. Yeah,
Ashley, do you agree?
Absolutely.
And so far, do you think it's been the right move? I mean, do you think he's been convincing in saying that this car was a perceived threat and he was, you know, worried about the life of his partner?
You know what? I'll be honest. His demeanor, he's consistent with his answers and he's thoughtful about his answers. But I personally do not find his demeanor speaks to me in terms of being sympathetic or feeling like, wow, this poor guy really feared his life or his partner's life. So I don't feel like it's really compelling testimony yet.
All right, well, let's listen back in now and see how the cross-examination goes from here. Looks like we're still hearing some arguments from an attorney. Welcome back. It appears perhaps there is a little break in court. We know attorneys were just arguing, it seems, over a Facebook post that prosecutors wanted to introduce a Facebook post from Roy Oliver, the defense objecting and saying that they didn't want it in there to begin with, but if they're going to introduce it, just show the photo from Facebook. We're not sure what that shows. Curious to see what it is. Hopefully we will find out right after this break. We'll be back in just a few minutes. Stay with us. Welcome back to Law and Crime. I'm Stacey Delikat. We are continuing to cover the trial, the murder trial of former police officer Roy Oliver out of Texas. Right now, there's a little sidebar going on. Attorneys are arguing over a piece of evidence that the defense wants to introduce. We just learned a little bit more about that. Apparently, Roy Oliver, we know, is on the stand right now. Cross-examination is going on. And what we've learned is that the defense wants to bring in a Facebook post, presumably from Oliver's page, that says, "I was placed on earth to kill." Now, we don't know whether those were his words or it was like some sort of meme or image that he posted that had those words on it. The defense objecting to that being introduced. No surprise there. Evan, what do you make of that?
I'm with the defendant in keeping this evidence out. This has no place in a murder trial. Well, what is the probative value of somebody's Facebook post of a phrase like this without any other information?
Right.
He could be photographing something because he thinks it's funny. He could agree with it on some level, but the prejudicial impact of a statement like that greatly outweighs its probative value.
Yeah, and I misspoke before. I meant to say the prosecution wants to bring in the Facebook post as evidence during their cross-examination. Ashley Willcott is also with us via Skype. First of all, what do you make of that in general, that there's some Facebook posts he made presumably quickly, because it looks like he's resuming, that said, I was born to kill?
As a judge, I also want to know the relevance factor. So if that was a Facebook page that he put up right after the shooting occurred, then I think it might be relevant and not as prejudicial, but it depends on the circumstances around it.
Okay, let's go back and listen in live. We'll discuss more in a moment. Well, that was the body cam footage. That was from the body camera worn on Roy Oliver's partner, Officer Gross's uniform as this shooting happened. Now, this is all about these young men. The victim here, 15-year-old Jordan Edwards, was in the passenger seat of this vehicle, the vehicle that we saw backing away from the officers. Roy Oliver is trying to convince jurors that he was really worried this car was coming at his partner and could hit his partner. But I want to ask my two guests. I have Evan Lipton, criminal defense attorney in studio, Ashley Willcott, juvenile judge and trial attorney, with us via Skype. I mean, when you see this video, it just seems, at least to me, the car is backing up the whole time. It doesn't seem at all like the car is approaching the officers.
Yeah, that's the way it looks to me. But I think it's important to remember there's a whole lot of body cam videos that were taken this night. We, in previous parts of this trial, have seen them side by side, and there is some confusion as to what's going on. These videos are not clear. It's a pretty chaotic scene. But I do agree, you do not see this car moving forward in any way.
Yeah, what do you think, Ashley?
You know, I do think it's chaotic. There's a lot of gunshots, a lot of things going on that are going to be fearful, right, and invoke fear. But I think this video is damning. I'm going to disagree and say, listen, I watched this video. In spite of the chaos, in spite of some of the difficulty seeing it, it's a damning video to me that this car wasn't threatening this man's life or the partner's life.
Yeah, well, you know, it will be interesting to see how the jurors perceive this video and the other video as well. Let's go back into the courtroom right now. The judge, it seems, is going to be reading some new instructions to the jury as they're led back in. Presumably, this is based on the arguments attorneys just had over what evidence and what witnesses can be introduced. Most of what they have been talking about has to do with Officer Oliver's character. All right, the jury finally now coming back in after these back and forth arguments over various pieces of evidence that prosecutors wanted to introduce. Evan, you had said to me before, I mean, there were so many different items they're going over here, a Facebook post, a psychiatric evaluation, a testimony he made in another trial. Why wasn't this stuff worked out beforehand, right? You had asked that.
In every courtroom I've been in, this type of evidence, it's 404B type evidence under the federal rules, which they seem to be following in Texas as well. This stuff is decided pre-trial, and a defendant should be able to consider the rulings that are made when deciding whether to testify.
Right. I mean, especially, it's not like it's just one piece. It's all these different pieces of evidence that the judge is being asked to decide on, and that, you know, obviously it slows down the trial a little bit. It's an interruption for the jurors.
But this guy's already on cross, and now he's got to decide whether or not he's going to be responding to questions about some psychiatric report from 7 years ago. That decision should have been made before he took the stand.
Yeah, Ashley, do you agree that this is unusual, that they are sort of fighting this out right in the middle of his testimony?
Absolutely. You all took the words out of my mouth earlier. I was wondering why in the world this is going on now, because every trial I preside over, every trial I've been in as a trial attorney, you do this ahead of time. You don't do this during the trial.
I mean, should this evidence, a Facebook post, I mean, like you had said earlier, it sort of matters the context of the Facebook post. Let's say this was a post made shortly before, shortly after the shooting, the psychiatric exam, the fact that he was very testy and used profanity when testifying in another case. Is that evidence that should be allowed to be introduced in a case like this, when this is about the officer and his character, right?
If it goes to character traits, and I think there's an argument that it could be admissible. I think the other thing that I wonder in this case is whether or not they knew of all this evidence before now. That's the only reason I can think about why they're discussing it now and whether or not it comes in.
But, I mean, this shooting, right, was a year and a half ago almost. Why would they just have found out about, say, a Facebook post or all of these things? I could see if one thing popped up now, but all of this together, I mean, how could they have just, what do you think, Evan? Do you think it's possible maybe they're just becoming aware of this?
It doesn't seem possible to me, and if they were, the question would be why they weren't aware of it before then. You know, the judge should be protecting the defendant from this.
All right, well, it seems like the jury is finally back in. Everyone is sitting down, and that the testimony will finally resume. So let's go ahead and listen live. Roy Oliver still on the stand, and the prosecution will continue their cross-examination. Well, that looks to be it for Officer Roy Oliver's testimony. The cross-examination not taking that long, but let's ask my guests, what did you guys think? Evan Lipton, criminal defense attorney, and Ashley Willcott, juvenile judge and trial attorney, is with us via Skype. What did you think about, prosecutors asking him about this prior court appearance when he was testifying, when he said, I don't understand the expletive question, he got suspended for that. This Facebook post, that he made that said there's nothing I'm better at than killing people, or it was a repost, rather.
Well, I think it was effective. I said before I was surprised that it was let in, but since it was let in, the idea that he could not control himself in a courtroom where some assistant district attorneys were annoying him because they weren't moving as quickly as he wanted to, really suggests that he's the kind of person who wouldn't be able to control himself in a situation like this, the subject of this trial. And I don't think the efforts to rehabilitate him on that are that helpful either. To show that he had a reason for being annoyed or a reason for being upset doesn't help.
Right, that he hadn't gotten a lot of sleep before, he had some disagreement with the assistant district attorney.
Exactly what you were talking about before.
Ashley, your quick response, your 15-second response, how do you think he did in that cross-examination overall?
Let's talk about his demeanor. I just felt like he was very stoic, that he didn't show any remorse, that he didn't show any regrets, and he said, yes, I accept, I did it, I acknowledge I did it. But wasn't speaking to me because of his lack of remorse or at all any sympathy for the victim.
All right, well, we're going to take a quick break. When we come back, there is a use of force expert on the stand. We will take you live there in just minutes. Stay with us. That is Captain Jay Coons, a use of force expert that has been called by the defense, talking about his background. My in-studio guest, Evan Lipton, has to leave us in a few moments. Before you do, I want to get your final thoughts on Roy Oliver on the stand on that cross-examination. Were you surprised that it seemed to wrap up as quickly as it did?
I'm surprised it wrapped up as quickly as it did. There was a lot more ammunition for that prosecutor. I don't know why he decided to do what he did, but I'm sure he had a good reason.
You said he wasn't very confrontational either. I mean, that can be helpful as well, though, right?
Not with a guy like this, who I think you could rile up with a little bit of confrontation. That could have been useful to see him get angry on the stand.
Yeah, Ashley, were you also surprised? Ashley Willcott is with us via Skype. That the prosecution didn't press harder or go further.
I am surprised, but on the other hand, I think it was a strategic decision based on the testimony that they'd heard, and I guess they decided, his demeanor and what he had to say, they could let it go at where they finished and stopped and not have to get him riled, I guess. That's
Evan, before you sign off, Ashley's going to stick around. You're a criminal defense attorney. What are your thoughts on what we've seen so far? Does this guy have a chance of getting off?
I really can't answer that question yet. I didn't get to watch the whole direct this morning. I'm not in a position to answer yet.
Okay, I understand. Well, listen, we do thank you for your analysis here in studio today. It was very helpful. Luckily, Ashley is sticking around. We're going to take a quick break. When we come back, we're going to go back live into that Texas courtroom where testimony continues. Stay with us. All right, a little courtroom break there. The judge, the jurors, the attorneys, the defendant, all stretching their legs. We were just hearing from Captain Roy Coons, Jay Coons rather. He is a use of force expert who just testified that in his opinion, the actions of Roy Oliver during this shooting of Jordan Edwards back in April of 2017 were, in his words, reasonable. Ashley Willcott, trial attorney, juvenile judge, still with us via Skype. This is the second use of force expert we've heard. The prosecutors called their own use of force expert who testified that this was not reasonable. So how did the jurors make sense of this?
Well, it's not atypical to have two experts that are going to testify against one another, basically, especially in a use of force. And so I think that the jurors are going to be responsible for weighing the evidence and considering the credibility of each expert, the qualifications of each expert. You'll note that the defense did go into all the specific qualifications of this particular expert in depth, and they do that so the jury hears it as this is somebody who really knows their business and has said, hey, it was an appropriate use of force.
Yeah, I mean, it was almost, a half an hour of hearing his qualifications and background. Certainly seems to have a lot of experience, though I think he had said he had experience with just 3 shootings. Does that make a difference? You know, how many shootings he's examined or been involved in?
Absolutely. It makes a significant difference because if you have one expert who's been involved in 100 shootings and one who's been involved in 3, necessarily you kind of think in your mind, hey, the one with more experience is going to have a better ability to have an expert opinion that's more credible.
All right. Well, Ashley, thanks for that analysis. We're going to take a quick break. When we come back, much more on the Roy Oliver trial. We're also going to recap today's top crime stories, so stick around. We will be right back after this short break. Well, thanks as always for that, Anthony. And on that last story about Mollie Tibbetts, we did get some breaking news in the last hour, and that is that the autopsy report has been complete. The medical examiner ruling that Mollie Tibbetts' death was a homicide, that she died by because of sharp, blunt force, I believe it was. So saying that she was killed by sharp force injuries, rather, and multiple sharp force injuries at that. We did not get any additional information yet, but just as soon as we do, we will bring it to you. In the meantime, Ashley Willcott with me via Skype. She's in Atlanta, and Ashley, talking about the immigration status about the suspect in this case. Unfortunately, this horrific murder has gotten so publicized, but the fact of the matter is the employer, the farm that he was working for, says, you know what, we did vet him, maybe not through E-Verify, but we used an older Social Security verification system, and the numbers came up. Okay, that's because we've learned he gave false information, right? So is it the employer's fault in this case? I mean, how much onus should be placed on an employer in a case like this? They did what they were supposed to theoretically because they said, what's your social security number? Give us your information, whatever it is. And they ran it through a system.
Right. So first of all, it's not the employer's fault that this happened. Obviously, unrelated to his working is the fact he committed this horrific crime. Second of all, that's what the employer has the responsibility to do, in my opinion, in the due diligence. Now, if E-Verify is required in that state to be done and they didn't do it, well, then you have an issue. But otherwise, if they used other tools to run the same kind of check and it came up okay, I think that's all they can be expected to do.
Yeah, you know, on the topic of the fact that the stolen ID, right? So is this going to be another charge that he now faces? I mean, does it even matter stacked up against a murder charge?
Oh, I think it does. I think you need to charge a defendant with all of the crimes that they've committed or allegedly committed, right, that the prosecution wants to prove, because it also goes as to the immigration status and what's going to happen. Is he going to be detained or not detained? Is he going to be deported? So absolutely, I think he needs to face all of the charges that he's accused of.
All right. Well, as we know, this story developing every day. Perhaps we'll hear more about that autopsy report later today.